Good morning, and thank you for being here with us on the Alabama Way. This morning in our studios, we have attorney Jimmy Calvert, and today we're going to be talking about bankruptcy. So many Americans have faced this, and I think a lot of people don't understand the laws and different things about bankruptcy. So we've got someone in our studios this morning that's going to kind of tell us, kind of clear some things up for us. Thank you for being here with us.
Well, thank you for having me, Deborah.
Wonderful. First of all, are you an Alabama fan?
Roll Tide.
Listen, we love our Alabama fans here on the Alabama Way. Listen, you've always been here in the city of Birmingham?
Yes, ma'am. I grew up in Birmingham.
Wonderful, wonderful. Okay, first let's talk about bankruptcy. What is bankruptcy? You hear that, but what is it?
Yes, ma'am. Bankruptcy is an area of law that allows an individual or even a company to terminate their debt if they fit the criteria, or restructure their debt over a certain period of months, and it's called a plan. It's a way to consolidate debt or terminate your debt.
Okay. Now, when should a person consider bankruptcy? I mean, when do you think, okay, I may need to look at this?
When the individual, let's speak on the individual level, not outside the company level. On the individual level, if a person believes that they cannot satisfy their monthly budget, they are not going to have the funds available at the end of the month, end of the year, or a certain period of time, they may want to consider contacting a bankruptcy attorney to seek assistance.
Okay. Is there any steps to take before having to file bankruptcy?
After meeting the attorney will have some requests for evidence of income. There is an online credit counseling that you have to take. Attorneys use different companies. The one I've been using, I started using them first of this year. A prior company I used for about 11 years.
Okay.
Of course, there is costs involved, attorney fees involved, depending on where you go to seek assistance.
Okay. Now, I know there's what you call a Chapter 7 and a Chapter 13. What's the difference in those? Chapter
7 of the United States Bankruptcy Code is basically a liquidation of your debt.
Okay.
Termination of all debt, with the exception of non-dischargeable debts, such as on the consumer side, such as student loans, federal and state income taxes and taxes, and child support alimony obligations.
Okay.
And a Chapter 13 is a debt consolidation. As long as the individual can qualify to file a Chapter 13, they can consolidate their debt into a 3 to 5 year payment plan.
Okay. Now, who determines what chapter you do, if you find yourself there?
Normally, it's wise to try to seek a Chapter 7 case due to the costs. It's less costs on the client. They do not have a debt for a long period of time. But in order to qualify for a Chapter 7, you cannot file a Chapter 7 for 8 years from the date of filing.
Okay.
Most people that have to go into a Chapter 13 case are people that have filed within the last 8 years. Their income may max out the means test that's allowed in Alabama, or they may hold certain assets that they stand to lose with the complete liquidation Chapter 7 case.
Okay. And what do you mean by the means test?
Means test is set up in every state. It's an average income based on number of different households, based on federal guidelines. And they're not just bankruptcy qualifications, but many other federal qualifications apply the means test. It can be looked up on Google.
Okay. Okay, now, I know the credit score has what happens to your credit score when you file bankruptcy?
Your credit score will be affected, of course. It's obvious. Chapter 7, Chapter 13 bankruptcy will stay on your credit for a period of 10 years. And I tell people, well, it's the way that you use your future credit. Someone has a home, has a car, and they have it financed. After bankruptcy, they can make their regular scheduled payments on time and start building a positive credit history. Even a secure credit card, various companies have them available where the customer sends in $100 and the credit card company sends you back a credit for $500. That is considered a secure credit card. And if someone would charge a small amount on it every month and pay it off every month, they can use it as a tool to help build their credit.
Okay. Excuse me. Now, will creditors, will they stop harassing you when you file bankruptcy, or is that something they can keep doing, or what?
No, ma'am, they cannot. Once a petition for voluntary bankruptcy has been filed in federal court, the debtor will receive a case number. Upon receiving the case number, any creditors that call the debtor after filing, they can give them that case number, and by federal law, the creditor has to cease collection efforts. And the debtor is placed into a period of stay. That's a legal word, S-T-A-Y. A period of stay that can normally last up to about 3 months in a general Chapter 7 bankruptcy. But creditors cannot communicate with the debtor without court permission or authorization by their attorney by and through the client.
Okay. Do you find anybody tries to get around that sometimes?
There are some aggressive collection outfits, you can say, but I have seen that. But once they are contacted and they verify that number with the federal bankruptcy court, they are required by law to cease communication and collection efforts. They cannot send a bill, cannot send a collection letter, or make a phone call.
Okay. If a couple is married and say one of them filed bankruptcy, will the spouse be affected?
I cannot 100% guarantee that the spouse will not be affected.
Okay.
If there's a joint debt and the filing spouse wants to surrender that debt, then the remaining balance of the account will fall on the non-filing spouse.
Okay.
If a spouse, say they're separated, and one spouse wants to surrender a vehicle that's jointly held, jointly financed, once that vehicle is surrendered, auctioned for the most part, how they dispose of the vehicles, there's a deficiency balance, the other spouse could be affected.
Okay. Now, who will know? You know, I know a lot of Americans are, people say, okay, I filed bankruptcy or whatever, and people want to know kind of who knows that I filed.
Your lawyer, people that you tell yourself. The lawyer has to keep your status confidential. Everyone that files a Chapter 7 bankruptcy has to attend a meeting of the creditors hearing within about 30 days after filing in the federal bankruptcy court. To answer your question, when you go to your meeting of the creditors hearing, there's generally a number of people in that courtroom that filed at the same time you did. They're lawyers, creditor attorneys, and a trustee. Okay, very informal proceeding. If you have a friend in that courtroom that filed at the same time you did, then that person would know.
Okay. But is it considered, it's public record?
It is public record. It is more difficult to discover than in your general state court, but it can be found.
Okay. All right, we're going to get ready and go for a break. And we're going to come back, and I kind of want to ask you, what are the most common reasons people have to file a Chapter 7 or 13? So you stay with us, and we'll be right back here on The Alabama Way.